It is August the 10th of 2026, and this is the Court Gallery. Today's cases are packed with individuals learning that actions actually have consequences. And for a few, it's not their first rodeo. First, we head to Judge Stevens' courtroom where a probationer tries to talk his way out of multiple violations with a string of empty promises. But the judge isn't buying the sudden change of heart. Later, Judge Buckley presides over a petty suburban HOA feud that devolved into a ridiculous street brawl fueled by fragile egos and far too much testosterone. Finally, we visit with Judge Coker in Yelm to witness an incredibly volatile defendant screaming at his attorney over frozen funds. All that and more starts right now.
Well, put it on the trial docket. Let's see, that's done. I think Langston is up on Fulton Fault.
Oh, we ready, Judge. That's a M2RG. And we are ready.
Here's
We're gonna move it today.
hey, I have Leander Elam, by the way, on a side note,
That's already played. I signed him up.
today.
Yes, that's
He's
done.
gonna be
Signed him up? I didn't see him on chat.
No, Elam.
Oh, it's not.
No, that's not Elam. This is his fault.
You're Mr. Colton Fall?
Yes, sir.
Does he need to go in front of you? It's a motion to revoke probation.
Yes, sir.
All right.
Judge,
19-31683 is called. Uh-oh. I'm looking at first amended. And
First Amendment.
first amended is right here,
I don't have a first amendment.
I don't have First Amendment. That's news to me.
you know?
Because what I showed him was just the MTRP that I got. But I didn't get a first. This is the only one I got is this right here. Unless y'all did something new that I don't know.
I've got one.
Hold on, everybody.
Got one.
Here's the problem.
Yes, sir.
Here's the problem.
The one I have is 5/7/26.
That's what I have.
Okay.
There's a new one. I don't know about that.
Somehow.
There was a motion to revoke unadjudicated probation filed June 27th of 2025. He
Oh,
pleaded true to allegations 1, 2, 3, 4, and 6, as well as 8 in November of 2025. What happened on that? Did we just continue him on probation?
I think what happened, Judge, you put him in a JCDI program.
Did we
Yeah, that's what
continued him on probation?
And the completion of that is one of the violations of this one.
Okay.
So
And
that's-
so we took care of that. Now there's a motion, and this says first amended on it, but I think we disposed of that first motion, right?
Okay, so maybe.
So this new one is going to be another motion with 4 new
Correct.
Violations.
That is correct.
Okay, so yeah, we're starting from scratch again. It's another motion to revoke probation.
Correct.
And this was filed on May 7th of this year. So June, July, almost 3 months ago. And you are Colton Chase Falk.
Yes, sir.
Raise your right hand, sir. Do you solemnly swear or affirm that any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Lower your hand. You are here with Mr. Adams, your attorney, the state's attorney, and the probation office is here. Does the defendant waive a formal reading of this motion? Can we proceed in summary?
Yes, sir.
In summary, sir, this motion to revoke unadjudicated probation, again filed May 7th, 2026. It alleges that on February 10th, 2020, in this criminal district court, you were placed on 10 years deferred or unadjudicated probation for the first degree felony of robbery. Actually, it's aggravated robbery. That's what makes it first degree, not second degree felony of aggravated. I'm going to amend this. Anybody object?
No objection from the state judge.
Oh, I'm adding aggravated, what he was properly placed on probation for. Any objection?
No, sir.
Allegation 1 states you failed to submit to alcohol and or drug screening. It says on or about March 21st, 2026, March 21st, 2026, March 24th, 2026, March 31st, 2026, April 9th, 2026. Then it shows April 13th, 2023. Are you kidding? We going back 3 years? Or is that wrong? Or is that a mistake? Is it?
Judge, that very well may be a typo, and we would abandon that particular allegation, Judge.
And April 21st of 2026, you failed to submit to alcohol and or drug screening at the direction of the probation office. That's a violation of condition 27 of your deferred or unadjudicated probation order, which states submit to alcohol and or drug screening at the direction of the probation office. Is that allegation true?
That's correct.
Are you pleading true to this voluntarily and because it is true as it is alleged?
It is 100% true.
You understand that a knowingly and voluntarily made plea of true to one or more violations of probation, that's enough to grant a motion to revoke probation. Your probation can be revoked. You can now be found guilty and sentenced in this first degree felony of aggravated robbery to no less than 5, no more than 99 years confinement in prison or life in prison. Knowing that, you insist on pleading true today.
It's true.
I find you're pleading true voluntarily. You understand and appreciate the consequences of pleading true. I'm going to skip 2, 3 states. You failed to successfully complete the Jefferson County Drug Intervention Program, JCDI, and comply with its rules in violation of a special amendment filed on November 12th, 2025. Is that true or untrue?
It is true.
And number 4, you failed to provide verification of entering and successfully completing the anger management program as directed by the probation office in violation of a second amendment filed on November 12th, 2025 to your probation order. Is that also true?
Yes, sir. That's true.
So again, are you pleading true then to allegations 1, 3, and 4 of this motion to revoke unadjudicated probation filed May 7th, 2026? You're doing this voluntarily, knowingly, intelligently, and because it is true as it is alleged in each of these 3 violations.
It's true.
You understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that's all it takes to grant a motion to revoke probation. And in your case, your probation could be revoked. You can now be found guilty of this first degree felony and punished no less than 5, no more than 99 years confinement in prison or life imprisonment. Knowing that, do you insist on pleading true today?
It's true, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Is there an agreement?
No.
All right.
And the reason why, Judge, the
What
state.
do you want to do?
I was going to take it.
Go ahead.
Judge,
Go ahead. You can go first, Mr. Hammond.
Thank you. The state had made an offer of 5 years, which you just explained to him, 5 to 99 is the minimum. Right. And the reason why we decided not to take the 5-year offer that the state made is that
does he have credit for?
sorry. The reason that we did not take the 5-year offer and what we're doing is we're going unagreed to you, and he understands the risk. I explained to him the risk of going unagreed to you. However, by going unagreed to you, he does have an opportunity to at least complete the JCDI program if you allow him to. And I do understand that this is a deferred adjudication, so the court could move this from a deferred and go straight to regular probation. Possibly, but here's
How
what,
can I do that? He's charged with aggravated.
That's true.
what.
You're right. Yeah, it's, straight probation is not
Right,
possible
right, that's
under the law.
You're correct. So, but specifically though, you could allow him to continue to be on probation. And there's several accomplishments that he's had while he has been on probation. And I know that you take these technical violations seriously. He doesn't have any new criminal offenses. All of these are tech violations. And Judge, what I wanted to give my client an opportunity to do is I know that the state and Mr. Coleman did offer a minimum, which is 5 years, but he wants to continue to remain on probation. So I was gonna ask the judge to at least to consider some of the things that he had to say about that because he's accepted responsibility. He's played true to the allegations that you asked him about. So it's not like he's denying anything. The only real question is that will you allow him to stay on probation and not violate him? And I
I'm not
want
going to violate anybody.
Well, no.
I'll guarantee you that.
but you could
I want to make that clear.
right. But you see what I'm talking about.
Well, no, he would be violating the probation,
Correct.
not
Correct.
me.
Correct.
And that would be a finding I would make, but I want to just get something straight with you. You said he hadn't committed any new criminal violations back in, he
And this-
pleaded, he had earlier pleaded true of committing criminal mischief on February 5th, 2025 in Orange County, Texas.
I know.
Criminal mischief on February 6th, 2025 in Orange County. Committing the offense of assault, family violence, March 29th, 2025 in Orange County, Texas. Provided a urine sample that tested the presence of cocaine and amphetamines on May 6, 2025. Technically, that's illegal possession of a controlled substance. Those are 1, 2, 3, 4 violations of the law that he pleaded true to in he pleaded true in this motion to revoke probation filed a little over a year ago on 6/27/2025. And for some reason, and then he failed to report all the numerous times on that. So man,
I guess when I speak.
what we did was like we ended up amending his terms of probation, I guess.
Yes, at that time, I believe you continued him.
I held the MTRP, but he admitted to
Right.
3 or 4 violations of 4 violations of law at that time. So
Right.
he's not pristine on.
No. I guess let me more specifically clarify what I was saying. On this MTRP, there's no allegations of a new.
I understand.
Well, so that's what I really meant. But Judge, I guess what we hear is that, yes, I understand that the state offered the 5 years. He's asking you to continue. That's why we unagreed. So what I want to do is call him. It's not like he's not accepting responsibility. He's accepting responsibility for everything. So with that being said, is he and myself wanting to convince you to allow him to stay on probation and let me have you state your name for the record real quick.
Colton Falk.
All right.
And you're still under, Colton, we put you under oath at the beginning.
Okay.
Oh, okay.
So Mr. Falk, you understand that the state had offered you 5 years on this, right?
Yes, sir.
And you said no to that, right?
Yes, sir.
And you wanted an opportunity to talk to Judge Stevens about continuing you on probation. Is that right?
Yes, sir.
So in talking to him about continuing you on probation, let's talk about some of the highlights why you've been on probation. Because that might be a reason to keep you on probation. We talk about the good things, right?
Yes, sir.
Okay. One of the good things why you were on probation is that you completed the Safe P program, totally completed it. Is that right?
Yes, sir.
And just so we're clear, what's the Safe P program? I'm sorry.
In 21, I believe in August.
Okay, go ahead.
All right. So positive since you've been on probation, and just so the record is clear, the Safe P program is what? What is that program?
It's a substance abuse felony punishment.
Right. And you completed it in full, right?
Yes.
All right. Another positive why
When was that?
I think he said 21.
Yes.
All right.
Hold on. Well, we're gonna go on that. That's great and fine, except subsequent to that, you pleaded true to having possession of cocaine and amphetamines in your urine on or about May 6th of 2025, which was a violation of your probation subsequent to that program.
Yes.
So that program wasn't foolproof. It didn't keep you from falling back and making a mistake in using drugs again, right?
Yes, sir.
And we're not going to go into the ugly side of this, but we could of where's your cocaine coming from and the methamphetamine, unless you're making it yourself, which is another crime. So, we put you through that program. That was successful, but how many chances do you get? We put you on probation. When we put you on probation, that was your second chance. You've committed these violations, 1, 2, 3, 4 crimes, and I gave you a third chance.
Let's not wait. Let's do it.
And you're asking for a fourth.
Right. And here's the second major accomplishment you had while you was on Judge Stevens' probation is didn't you complete your GED?
I did that as a Estelle unit in safety.
Right.
I'm sorry.
When I was in a Estelle unit, I obtained my GED.
That's important
He got his GED.
because education makes you wiser
Right.
if you want to make that decision. Some people know the options and they still choose the bad option. Education makes you wiser. It won't tell you what to do. It'll tell you what's the better choice and the worst choice. Then it's still free will on your part.
Yes, sir.
Okay, go ahead.
And then the next thing is that if we look at the date that you were placed on probation, I see it was February the 10th of 2020. You see that date right there?
Yes.
And then today's date, I believe, is August the 8th of 2026. So we're talking about a 6-year period, right?
Yes.
All right. Now, to my understanding, when I met with you, when you initially had your prior hearings before Judge Stevens, one of the things that came out was, and I wasn't your lawyer then, but one of the things that came out was your children, right?
Yes.
And
Say that again.
his children. He has 2 boys, right?
Yes.
And while you had those 2 boys before Judge Stevens, to my understanding, I wasn't there, but I mean, Judge was there, but to my understanding, one of another accomplishment of yours while you were on probation was you got custody of your kids. Didn't you tell me that?
Yes. It was ordered by him, actually.
All right. And can you explain? Because we're trying to get the judge to keep you on probation, right?
Yes.
So in keeping you on probation, judge basically saying, hey, you need to do something about these kids. And then in response to Judge Stevens, what do you do? Just tell me what you do in your own words.
Well, whenever I got out of safety, I was here for a 6-month status update, and you were made aware that I have kids and that I didn't have custody of them. And you said you wanted to see me back. I think it was 3 months. It could have been 6, but you wanted me to have custody of my kids along with a few other things that I needed to take care of, including catching fees up and stuff.
It's a parent's obligation.
Yes, sir.
Some don't follow through with it like they should. But yeah, I've always felt like you were capable.
Right. So as a positive to ask Judge.
When did you get the custody of the children?
A couple months after you told, maybe not even that.
What's the date about that?
I believe it was the end of 22, probably, maybe the early 23.
So the bottom line.
Bless you.
Right. So the
But
bottom.
hold on, that's great. Except subsequent to that, you commit criminal mischief, 2 criminal mischiefs, and an assault, family violence, as well as possession of cocaine after you had the kids. What are you trying to tell me? What's good about it? You're putting children into an environment that's terrible. You're showing me, look, here's my hand.
Mm-hmm.
Do you see my hand?
Yes, sir.
Do you?
Yes, sir.
Or now do you see my hand? Just don't show me one side. I've got to see both sides.
Yes.
Great getting the kids, but thereafter you commit 4 crime violations on my probation. Where's that good role modeling for the kids? But I say great, wonderful. The kids need support and role modeling and good examples. And that's why I'm disappointed more than anything, because I felt you you were capable of this better. That's why I'm just disappointed. I always, when I pitched in school, I wanted to pitch a no-hit shutout every time, a perfect game, and you don't. Hardly ever happens. But that's the way I am. I don't like failure. And I'm disappointed with this because I thought better. I had better feelings. But I don't know what you're trying to say. Getting kids is one thing, but you put them in an environment where you commit 4 crimes while you're on probation. While you're on probation for this serious crime of aggravated robbery, my God, which can take you to life in prison.
So basically, after the judge told you to make sure you're taking care of your kids, and then you get custody of your kids, but you tell the judge basically how those kids been doing in the 6-year period.
My kids are great. They're actually, my mom, since I was arrested, she stepped up. She has them temporarily.
I know.
And
I'm sure she's a good role model.
She's done amazing for me.
I know, but you're the parent.
I know. It's not her responsibility at all. And
Okay.
they're doing great. I don't like that they bounce around so much between schools, but where they're at now, I'd like to keep them in that school for the remainder of their childhood. But the stuff that had gone on whenever those new violations came about, I just went through a bad divorce, and it's an excuse. I'm aware of that, but
Everybody, not everybody, but it happens every day.
I just messed up. So
Marriages don't work, but why would you run out and get cocaine and methamphetamine? Criminal mischief, you must have thrown something around. It's not good.
Right.
But the kids don't have to be in an environment where y'all are hostile if it's because of that with your spouse, their mother.
Mhm.
I mean, that doesn't look good. But but you're throwing in cocaine and amphetamine here in this.
And then, Judge, I know you said that the kids, in spite of those regressions, have been doing well. I know your mom is going to testify for you as a character witness, and I'm not going to be long. But when we get to the allegations that you played true to, like the alcohol, the JCDI program, and verification community service, the big accomplishment of yours, I think, and I think the judge told you while you're on probation, you need to do this. The biggest accomplishment is steady employment, right?
yes.
And can you tell us about your steady employment and how that kind of interfered with you being able to do some of these things? In your own words, you tell them whatever you want to say. Go ahead.
Well, I've been employed ever since since I completed Safe P. I wasn't employed for I think it was 4 months I was here last year. And I did get behind on my fees there, but whenever I got out, I went to work right across the street from the jail at the Lindy Project. I was working there up until this till the motion was filed. Right about that time, I was going to change jobs, and once once the motion came out, the MTRP came out, that kind of put a hold on things. But I mean, I've always had a good job, and really, to be honest, that job is probably it's not the reason. I mean, I'm the reason, but that job had a lot to do with me not taking that JCDI program and running with it. It was taking a lot of my time, and I didn't take the program serious enough. And I would like to go back to work to where I'm working a little bit less hours, and I could complete that program if given the opportunity to complete it. But regardless, I mean, that's one thing that I've always done and always will do is I will work. I will have a good job.
So with all that being said, I know the state had offered 5 years. We went to judge.
Which is the minimum, by the way.
Yes.
Okay.
Right. We're asking judge to continue you and keep you on probation and allow you to complete the JCDI program. And here's my last question before I call your mom, because I know she's a character witness for you. And that is, in your own words, tell judge why you want to be continued on probation. You can tell them whatever you want to tell them. Go ahead.
I've thought high of myself since I was a kid. I've thought I was destined for great things, and then it didn't happen like that. I've slipped, I've stumbled, and I've gone from being somebody that she wouldn't let in her house by herself to somebody that is called anytime anything needs to be done at her house. And to go from a drug addict to somebody that earns that right again it is an amazing feeling. I'd like to get that back. I want to be proud of myself again.
Well, whose choice is that? It's your choice.
Yes, sir, it is.
Just make the right choice, which you're having problems doing. Then all of us are, everybody who's involved here is frustrated because we thought better of you. But again, you're saying the right things, but you go out and you still make the wrong choices. That's the problem. And all this event that the kids and work, that's fine. I worked since I was 16, 3 a.m. was my job, 80 cents an hour. Saturdays and Sundays making donuts. But it kept me out of trouble. Well, I don't know what the problem is with you. These are the wrong choices. And drugs again. There it is. And not going to drug screening when we were trying to help. But it's just, you say the right things, but you have to walk the walk, not just talk the talk. You have to make the decisions. And we've been struggling here for several years on the decision making. Over 6.5 years. You've been on probation, and this is another motion to revoke probation, but it's crimes and failures to follow the rules that we all believe you're capable of doing, but we can't carry you across the finish line. You got to walk yourself. You got to make the trek like we all do by making right choices. And shame on you, really. You have all the good reasons for it. You've got people who depend upon. That's what's so frustrating. But you come up here and say and then you admit I don't have really excuses for it. But you keep coming up to court, failing when we all know you're capable of better. Which just do it, but you have to pay a price for your falling down and failures. Because we keep, it's like somebody who touches the stove. You're embracing the stove now. Mm-hmm. You're embracing it. You know it burns. It's going to burn you, but I don't know what it is. You still fall back and make the wrong choice.
And Judge, while the state did offer them the minimum 5, and we definitely appreciate that offer, his only chance of continuing to be on probation is with you, and with the decision, whatever decision that you make is his one chance of that. And that's why he wanted to come to you directly to give him that shot. And then my last witness, and it's gonna be long, is his mom. I don't know if Mr. Coleman has any cross-examination for him.
I don't have any cross-examination. State
Come forward.
would like to be heard at some point, Judge.
You're gonna get a chance.
And I'm only gonna ask you 2 questions, and I want you to give you a narrative response as best you possibly can. And here's the first question. The first word is state your full name for the speakers. Introduce yourself.
Raise your hand. First of all, you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth. So help you God.
State your full name for the record and introduce yourself to the judge.
Hi, Judge. We talked the last time we were here.
Yes, ma'am.
Barbara Falk, Colton's mother.
Yes, ma'am.
So you remember talking to the judge the
Oh,
last
yeah.
time?
We talked after court was over. At some great length.
Okay, all right. My one question for you is this. You love your son, you care for your son, you understand that Judge Stevens can make a decision to continue him on probation. You understand that, right?
Yes.
So in your own words, without me leading you, I want you to say whatever comes to your heart. Talk to Judge Stevens as to why you're asking him to continue your son on probation. Look at him and tell him what you want to say. Go ahead.
Colton's dad, we've been divorced for years, is not doing well. If Colton goes to jail, I don't think his dad will live till he gets out.
Yeah, our life.
There's not a love.
Our life touches
lost.
others. We don't live by ourselves on this planet. Our life touches other people's lives. What we do affects other people, not just us.
Right,
Don't
right.
finish what you said.
But, I mean, his boys need him. Like, I'm retired. I was never thinking I was gonna start over again, raising kids, which I love my grandsons. They've got new bedrooms, new bikes, they got their school clothes, their school supplies. I'm ready. And they're happy to be where they're at. They love their granny. I get them in the kitchen, they help me cook.
Look, you use a father,
It's
Mhm.
a
true.
responsible father.
They do need their daddy. And you
Well,
love
not big. Dad that is consistent on bad role modeling and bad examples. Right?
Yes, sir.
All your choices. Got too many people relying on you. You don't live on this planet by yourself. You have responsibilities. But you have to act responsibly. Okay.
So what I'm hearing you saying is that, and I'll be quiet, is that if he's revoked, that impacts not only you, the children, his dad who may be dying, family members, himself. He's gainfully employed. So at the end of the day, with all that being said, in your heart, your soul, are you asking judge to keep him on probation?
I am.
Judge, I don't have any other questions. I don't know what Mr. Coleman asked.
Yeah, but you don't have anything, do you?
No, Judge.
Okay. Ma'am, just please have a seat. Thank you. Anything else?
Judge, I think I kind of summed it up.
I understand what your position is.
And I'm just asking, and he's asking to continue the supervision.
Okay. From prosecution.
Your Honor, inevitably, when we get to this point in these types of cases, these MTRPs, there are a number of advocates for the defendant. You've got Mr. Adams here who's advocating on his behalf. You've got his mom who's advocating on his behalf. I, Judge, stand before you today to advocate for a Mr. Manuel Gaspar Jr. You know who Manuel Gaspar Jr. was? He was a 71-year-old disabled veteran who walked with the assistance of a cane that this defendant pushed down in an ATM and stole his $300. That's the underlying offense, the circumstances for which this defendant was placed on aggravated robbery, deferred adjudication probation, Judge. I'm here to advocate for Mr. Gaspard. I would venture to guess what Mr. Gaspard would say about all of this business about a second chance, third chance, fourth chance, blaming everyone except taking responsibility and taking that 5-year offer that I offered to this defendant, which, by the way, is the minimum, which, by the way, was predicated upon this defendant walking in here, accepting responsibility, taking that punishment, and not putting the state and through this hearing, and for that matter, his mom through this hearing, Judge. We would ask that on behalf of Manuel Gaspar Jr., 71-year-old disabled veteran, that you revoke this defendant's probation, reform the judgment, and send him to TDCJ where he's earned every bit of it. Thank you, Judge.
What are you asking for?
Judge, the 5 years was again predicated upon him accepting responsibility and not putting us through a contested hearing. I would ask for something more than 5 years. And of course, that's within the discretion of the court.
Judge, nothing has changed. Notice what he said. It's predicated upon him accepting responsibility. Every allegation you asked him about, he said true. So if that's the argument they make, then follow it to his logical conclusion. He did accept responsibility. The reason that we didn't take the 5-year offer is that you are our only hope of continuing on probation, and that's why I brought
No,
him.
at the end of that's incorrect.
Well, he is, but you can.
He is in control of his destiny, really
Right.
not me.
Right. And so what we were asking is based upon what you heard him say, based upon what you heard the mother say, and the accomplishments that he's made, Judge, we're asking you to give him one final shot. Absolutely one. But he did accept responsibility because he told you true to everything. Everything he said true to.
Anything else? Anything from the defendant?
No, is there anything else you want to tell him that I missed?
You haven't missed anything. You've done an outstanding job. I know that I messed up, and I am just asking you for one more chance.
And there's consequences for everybody. You do well, you're rewarded. You do poorly, you get punished. It's the way it is supposed to be. Or it wouldn't be fair for the people who do well. Doing well would not be something important and good and genuine. Rewarding. Anything else?
Judge, We're just asking for the mercy of the court on that.
Anything else?
No, no.
All right. Okay, and then it's before me.
Yes,
If
sir.
nobody has, the court is going to find that there is sufficient evidence supporting this motion to revoke unadjudicated probation, to grant it by preponderance of the evidence or greater, as allegations 1, 3, and 4 are proven true, as the defendant has voluntarily, knowingly, intelligently, based upon advice from counsel, admitted to those 3 violations. Only one is sufficient, but the court finds that those 3 are proven true by a preponderance of the evidence or greater, and this motion to revoke unadjudicated probation is hereby granted. Earlier in this case, sir, you had pleaded guilty to the first-degree felony of aggravated robbery voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this first-degree felony of aggravated robbery. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You will be given credit, and it's almost 500 days you've served toward the satisfaction of that sentence. And it can't go without noting that the essence of this crime was committed on a disabled veteran, 71 years of age at the time. And there is the video at Chase Bank, which shows which shows you entering the bank, and that Mr. Gaspard, the victim, is there first. You came afterwards. He is walking with a cane at 71 years of age and being disabled. You enter, and as the victim is retrieving $300 from the ATM, you used your body to push him out of the way while grabbing the money. And Mr. Gaspard fell against the glass wall of the kiosk. You fled on foot, and the victim can be seen slowly walking to the kiosk door and using the assistance of the wall to help balance him. Well, that is a terrible set of facts for somebody who's telling me about how selfless he is and dealing with his family. And this is an aggravated case, and you're being held responsible. And you're being held responsible in spite of what you're telling me. You know, you have dependents at home who rely on you and need you. And you speak all the good things, but you're here on this motion, a second file motion to revoke probation, not submitting to alcohol and drug screening on numerous occasions where the probation office was trying to help you, not successfully completing the drug intervention program, and not entering the anger management programs, and not long ago you pleaded true to 2 criminal mischiefs, a family assault, and illegal possession of cocaine and amphetamine. It's more than enough to hold you accountable this is all while on probation, when you knew one violation is enough. The court finds that this decision, the other court, is in the best interest of justice based upon the circumstances of this offense. And the court is under these circumstances that we're talking about is a light sentence. Gives you the some time to serve, and then when you were released, you get to go back to your family. But I'm feeling sorry for the kids, but certainly for the victim, a disabled veteran who deserves respect. Trauma. That is all.
Thank you, Judge.
Thank you, Judge.
And Abigail Pitt-Blotto. Ms. Iverson, good morning.
Good morning.
All right. Apparently Ms. Pitt-Blotto has not been served. Is that your understanding?
Excuse me. My understanding is that she was served on Thursday and that proof of service was sent back to Thurston County. I confirmed that on Friday when I called.
Okay, apparently it was just filed. All right. Like Ms. Pitt-Blotto is currently at Western State Hospital.
That is correct.
And Ms. Iverson, for the record, you indicated in your petition that Ms. Pitt-Blotto, who is a neighbor of yours, correct?
Yeah, that is correct.
All right. Do you have video capability there?
Yeah, just one moment. It's set to safe driving mode, so it doesn't
Okay.
want to turn on my camera. If I leave the meeting and come back, I can turn it on.
You're not driving, are you?
No, my phone defaulted to safe driving mode.
Okay. All right. Then we'll just work through it as we are now.
Okay.
All right. So, Ms. Pitt-Blotto's neighbor, it looked like there might be a criminal investigation for assault for her having thrown a bottle at you. Is that correct?
That is correct.
Okay. Do you know what the status of that investigation is?
My understanding in talking to the prosecutor is that she was ordered for treatment at Western State, and then pending that treatment, she'll either be found competent or not.
Okay,
And so
actual charge has been filed.
the hearing
Sure.
for that, I believe, is August 11th. That's all I know about the criminal. I haven't received any updates on that. So the prosecutor suggested I do a civil in lieu of that because the criminal one may not stand and I would not have protection.
Okay. Yeah. And just so you know, I'm looking now on Ms. Pitt-Blotto's criminal history. There is no formal order or no formal charge that's been filed. I'm guessing what the prosecutors are looking for is to decide whether to charge it at this point. So that's how it looks.
Okay.
All right. And besides the bottle throwing, you'd indicated that she has been harassing you. Is that correct?
Yeah. I don't know how much detail you want me to go into, but yeah, it's been.
Just briefly summarize it for me.
Yeah.
In your
So I was weeding in my yard and she was in a very agitated state and came by and started shouting at me. And then threw the bottle at me and I asked her to leave. And then she came back the next day and took the bottle and asked the neighbor to dispose of it. And then she came back about 3 hours later. And I was outside speaking with a different neighbor and she started screaming at me and telling me that she didn't throw a bottle and that I was an effing liar and was getting more and more agitated. And then she asked if I'd called the police about the bottle. And I told her, yes, Abigail, that's assault. And I told you I'd have to call the police. And then she started screaming about how she's on probation and that she will effing kill me and curb stomp me because she's on probation. And she didn't throw a bottle and kept getting more and more agitated and then squared up like she was going to jump the fence and come at me. And so I just let her know if she comes on my property that I'll have to call the police again. And so she kept screaming and yelling and threatening me that she was going to, harass me every day of my life and make it a living hell from here on out. I was shouting, so a bunch of neighbors were watching. And then she walked around the corner and was standing in my driveway screaming at me. So I called 911 and asked them to come out, and they could hear her screaming. And then she kept walking and had a meltdown in the neighbor's yard. And the neighbor called and asked someone to come get her because she'd been there for several hours screaming and cussing.
All right. She's an immediate neighbor of yours?
She's one door down. So there's one house between the two of us, but our backyards you can see from her deck onto my deck. So it's pretty close proximity.
Any idea how long she's to be at Western State? Do you have that information?
I don't. It was something that I had asked for, you know, when the bottle incident occurred, that she would have a mental evaluation. I'm not sure how long those take, but she's been there since I think the 28th.
All right, Ms. Iverson, I have granted the full order because Ms. Piplotto was indeed served. For some reason, the temporary order wasn't filled out, so there were no conditions imposed. What that means is that I have now imposed conditions, and just for your information, those conditions are that Ms. Piplotto is to have not harm you or your children, not to have contact with you or your children, and not to come within 50 feet of you, your children, or your residents.
Okay.
The issue is with me imposing those conditions is it's a change from the initial indication that there was a temporary order. So she's going to need to be served again. So I've directed the Lakewood Police Department to serve her. So my strong suggestion is, since we don't know when she leaves Western State, she may still be there, which will make it easier for Lakewood Police Department to find her, is to work that issue today and see if somebody can get there to get her served before she's released from Western State.
Okay, I really appreciate that.
Yeah, she'll need to receive a copy of the order that I've just signed.
Okay.
A copy of the order will be emailed to you, Ms. Iverson, and then you'll need to arrange to get it to Lakewood Police Department. And like I said, you may want to do that sooner rather than later, because you don't know when she's going to be released from Western State.
Thank you. Yeah, there was a little bit of an issue with not having the service address on the temporary order. So it took me about a week to sort that out between Thurston County and Lakewood.
Right.
And then eventually Lakewood agreed to serve with me giving them the address. So is there a way for the address of Western State to be on this so that we don't have that issue again?
I think the way to do it is just contact Lakewood Police, say your understanding is that she's still at Western State where they served her last week, and just you think she needs to be served, today or tomorrow. All right?
Yeah, thank you.
All righty. Thank you. Bye-bye.
Bye.
All right, Ms. Piplotto.
Yes, here, Your Honor.
All right, are you up at Western State?
Yes, sir, I am. I'm in an enclosed room with nobody in the room.
Oh, okay. All right. We conducted your hearing earlier. It was scheduled for 9 this morning.
Yeah, my social worker told me that this wasn't important, and she refused to put me on Zoom. I got a hold of the charge nurse, and I said, oh boy, this is very important in my life. So he let me come into the conference room.
Okay. Well, at this point, I granted an order on behalf of Ms. Iverson telling you that you can't have any contact with her and you're not to go onto her property, not to go within 10 feet.
Okay, because I have some big problems with the 1,000 feet because my child's bus stop is out front of her house.
Okay, so sit tight for a second. Will you give me a contact?
Okay, sorry, I get it. I'm excited.
Yeah, that's okay. I understand that you're not the immediate neighbor, correct? There's at least one house between the two of you?
Oh my gosh, I accidentally hung up.
Okay. And Ms. Iverson?
Are you there? I accidentally hung up or exchanged the call on accident. Can you hear me?
I can. And
Oh, okay. Sorry about that.
that's okay. So sit tight for a minute.
Okay.
Ms. Iverson, is that you? With the hand raised, your name, please.
This is Mindy Wachter.
Okay, Ms. Walker.
Sorry, I just had one quick question.
Okay, you just hold on. I'm dealing with another case right now.
Okay, yeah, I didn't know what to do other than raise my hand.
Yeah, okay, I'll get back to you shortly.
Okay,
All
thank
right.
you.
Yeah, Ms. Pilato, so the order that I entered said that you can't go within 50 feet of Ms. Iverson's residence. And tell me how that works with the bus stop.
Well, my house, my house is paid off, and with all these problems, I'm gonna put it up for sale. So I'm not gonna be right next to her for very long. Let's see. So there's my house, there's a house, and then there's her house. Her house is on the corner. Let me think, 50 feet now. How far is that? 50 feet. I think I'd be all right. She works from home. She barely ever leaves her house. I could very easily not go on her property to have the kids go to the bus stop, and I could stay within 50 feet of her front door. That wouldn't be a problem.
Okay, yeah,
But
I reduced it from,
my house is pretty close to hers.
right, yeah, she told me that, but that's why I
Okay.
reduced it 1,000 feet to 50 feet.
Okay, and I apologize for all these problems. And if I wasn't drinking, I wouldn't have said those things, and I regret it. I really do.
All right, thank you for calling in, Ms. Piplato.
Okay, thank you, Your Honor.
All righty,
I'm
bye-bye.
gonna get the help that I need now. Okay, thank you.
Oh, very good.
Yeah, okay, bye.
Bye. Benjamin Kirby, Jeffrey Burt.
Yes, Your Honor.
Mr. Kirby, good morning, Mr. Burt.
Yes, Your Honor.
Would you raise your right hands for me, please? Swear the testimony in this case to be the truth, whole truth, and nothing but the truth.
I do.
Do.
All right. And two of you are neighbors. Mr. Kirby, are you immediate neighbors or just same?
We're not
area?
immediate neighbors. We're not immediate neighbors. Maybe 3 or 4 houses apart on the opposite side of the road. We live on a dead-end street, a one-road neighborhood.
All right. And you are currently on the HOA board, and Mr. Burt used to be on the HOA board. Is that correct?
Yes.
Okay. And I've read what's been filed, but Mr. Kirby, in your own words, tell me why you believe you need a protection order in this case.
I believe that Mr. Burt will continue to harass me. He's made several threats on more than one occasion. So I just believe it's going to continue. In fact, there was another incident that was more recent of his harassment of me. So it continued to prove that this type of behavior towards me is just going to continue unless I get a protection order.
And what do you think started this, in your opinion?
In my opinion, what started it was when Mr. Burt approached me and was upset that my boat was parked in our neighborhood, and he was making statements about how long it had been parked there, and I disagreed with him because it hadn't been parked there as long as he was saying that it was. And then he just snapped and started cussing and yelling at me because I didn't agree with him, that I disagreed and told him that, my boat's been parked here for this amount of time, and then he just snapped and started yelling and cussing at me and threatening me.
All right.
That's what precipitated it back in early June.
Okay, thank you. And Mr. Burke, go ahead.
Yes, Your Honor. What would you like to know?
Just, a summary of your side of the story here.
Yeah, Mr. Kirby is on the HOA, and he doesn't act like it. But I was in the retention pond cleaning out, just cleaning out cans that were there, and I had asked his neighbor about that, and she mentioned that she thought it was his kids that had thrown the cans there. He had come back. He was just arriving back. I do want to make note that his boat was unhitched. He tends to leave his boat unhitched in the neighborhood. And it escalated at that point. He said nobody tells him what to do, yada, yada, yada. And that was the first incident. I then asked for his removal from the HOA immediately after that happened. And one thing I do want to make note is after that first confrontation, myself and another HOA member started receiving text messages from Mr. Kirby, basically wanting to continue this when his children weren't there. And I could choose if I wanted to, however I wanted to continue this. But those text messages continued for about an hour or two, with the end of it being, you make the call when and where you want this to take place, basically. And I gave you copies of those. At that point, I was out blowing the sidewalk and street like I do to take care of my portion. And he did drive by. I motioned for him, and this is on the 23rd, that I motioned for him to roll his window down. And I basically asked him, hey, when are you going to follow up on this? And at that point, Mr. Kirby said, okay, you want to go? I'll go. He went up the street, turned around, came back, went into his garage, which I had no idea what he was doing at that point. And then about 5 minutes later, proceeded to come out and stand in a fighting position while he was stretching. And then basically, saying, okay, let's go. At that point, there were words exchanged up and down the street. I then decided that I was going to walk down there since he wouldn't come up. And the whole thing escalated with him basically baiting me to hit him because I know what he wants to do. And neighbors came out. I was separated. The police were called. I was not cited or arrested for anything. Since then, I was served by his roommate, and I have not engaged, talked, looked at him, or done anything to continue this. I don't want to have anything to do with the gentleman from this point forward. I will make note that I was walking my dog and he's videotaping me from his car. So I feel this is a two-way street, Your Honor. And I really respectfully ask that this petition be denied.
All right. So I see in your statement here that you said at one point you called him a pussy and laughed in his face, knowing that was going to agitate him.
Sure. I mean, yes, I did. I do not deny that.
Okay. And on the other side, Mr. Kirby, your thoughts about what Mr. Burt just said about you sending texts saying, let's finish this thing. Tell me about that.
Yes, that was in regards to the incident that happened in early June. He was calling me lots of names and calling me out and wanting to fight me. And I told him that I'm not going to do this. My kids were here. We were unloading our truck. My arms were full of stuff. I said, I'm not going to do this with you right now. He wanted to fight me. And I said, I'm not going to do it right now. I'm not going to do this in front of my kids. And he continued to insult me and berate me in front of my kids. And I said, my kids will be gone on Wednesday. We can finish this on Wednesday. Yeah, I did say that. And it took some neighbors to come and pull them away out of my driveway, away from me. And I did submit the video that my son began to take of the incident, because my son and my daughter were scared. The other HOA board member also joined in and yelling and cussing at me with Mr. Burt. And so, yeah, I did send him a text message. We exchanged text messages after that, and I told them that actually Wednesday, I'm not available, but if you want to prove whatever you need to prove on Friday, I'll be around. And then nothing happened for like a month and a half, and so I'm just like, okay, it's over. And then the morning of the I can't remember exactly what the date was, but when he was blowing the leaves in the road, and he motioned for me to roll down the window, I thought it was something, I didn't know what it was. Maybe something to do with the landscaping. I figured it was just over because a month and a half had passed. And again, he calls me a pussy and says, where were you? I thought you were going to come over and we were going to finish this. And I was like, all right, we'll finish this right now. And yeah, that happened. And I went and stood where I was standing before, and he walked down, and same thing. I said, okay, well, I'm not going to throw a punch at you. And if you want to prove that I'm a pussy, then throw a punch. And he just began yelling and cussing and calling names, and the neighbors came out, and one of the neighbors called the police, and he's like, yeah, fine, call the police. So he went back into his house. The police came, took my statement, and the Thurston County deputies, they're the ones that recommended that I file this petition along with my neighbor, he's formerly on the HOA board. They all recommended that I file this. They said that there's no indication that he's going to stop doing this. And so I said, okay, yeah, I guess I better do this, because, you know, I gave an opportunity, and I just need this to be over with. So that's why I went forward and filed it. And then I would like to make a statement about a more recent incident of harassment, which contradicts what Mr. Burt just said, that on August 3rd, about 8:15, he mentioned that he was walking his dogs. And I have to, when I leave the neighborhood, I have to drive past his house every time. I have to leave and come back in. I was taking my daughter to her volleyball camp around 8:15 in the morning, and as we're driving by, I look over and I see that he is walking his dogs, and he makes a motion towards me and my daughter, my 11-year-old daughter, of masturbating, and flips me off as we're driving by. And my daughter goes, that's Jeff. He's weird. And I said, yeah, I just don't worry about him. He's obviously, I don't remember exactly what I said, but I tried to comfort her. And then it was the next day, the next morning on the 4th, when he was served the paperwork.
All right.
So again, I believe it will continue. When I come home, it's like, okay, is he going to be out on the road again? If I bring my boat over for a day or two, is he going to harass me again for having my boat there?
Okay. Thank you. And Mr. Burt, anything else you want to add?
Yeah, his account of what happened when I was walking my dog is not correct. He was filming me as he drove by. I could see it, and I kind of motioned, like, go on. There was no masturbation. There was no flipping off. I would also like to note, again, this gentleman is on the HOA board. There's covenants that state you can't have a boat or a trailer or anything in here, yet he constantly breaks this. And he acts as if none of the rules around here apply to himself. And I may be the only one to ever say something to him, but he goes unchecked in this neighborhood. And I don't want to have a thing to do with this guy. I have no intention of interacting with him again. And other than going to the mailbox, which is located directly in front of his house, I don't even go down there. I used to mow the entire strip of the HOA property because our HOA is a non-functioning HOA and doesn't do anything to keep the neighborhood, up to snuff. And so I took it upon myself to mow this huge strip. I'm not even doing that anymore, Your Honor. It's too close to his house. I want nothing to do with this gentleman. I have, where my house sits, it's bordered by 4 different HOA properties. And so I would ask that he not come near my house in any way of the HOA. Again, I feel that this is two-sided. I feel Mr. Kirby plays a huge role, especially with the continuation after the first one of him sending email or text messages to me. It just at that point. And so, yes, when he drove by, I wanted to know what's the follow-up here? Are you going to back up your threats, or are you going to, what are you going to do? And for him to turn around and then go back to his house and stand out front in a fighting pose, what does that tell you? Again, I respectfully ask the court to deny this petition.
All right. Thank you, Mr. Coach. I'll make a general comment first. It's, sometimes we diplomatic here. You two guys are exhibiting too much testosterone, I would say, both of you. Guys your age, and by the way, I'm significantly older than both of you. Guys your age are just going to hurt yourself if you try to hurt somebody else. So, let's lay off the, let's get it on sort of thing. Teenagers do that, and that's where it should end when, as people mature and understand that that's not the way to resolve things. Also, as a former head of an HOA, I understand the tensions that exist, and, is the organization working well or not working well? And I get, that it's all dependent on the people involved. But it exists there to deal with general neighborhood issues, such as a boat being there too long, if that's the case. Mr. Burt, take your issues with the boat to the HOA. I heard you say you don't think it's going to do anything because you don't think it's a functional organization, but that's the organization that's set up to hear that type of inquiry. Clearly, that's not going to work with a direct confrontation with Mr. Burt. That's been made very clear. So that's the way you need to handle that. All right, looking at this, this is, I'm going to enter the protection order, and Mr. Burt, you're to have no contact with Mr. Kirby or his children, not harm them, and not go within 10 feet of Mr. Kirby, his children, or his vehicle and residence. And Mr. Kirby, this order will be in effect for 1 year from today's date. If you want it renewed, you'll have to come back to court and ask for it to be renewed. All right, the matter had previously been served on Mr. Burt, so he doesn't require further service. And honestly, I hope the two of you sort of say, yeah, that was kind of silly, individually to each other, to yourselves rather. It's, to me, it's a little embarrassing as a guy that we have other guys, sort of doing the bull moose thing. That's left for another generation. All right. Thank you both.
Thank you.
Your Honor.
Yes.
How do I deal with Mr. Kirby being on the HOA and yet my property is surrounded by 4 different HOA lots? One specifically is right next to my driveway, and Mr. Kirby has decided to take down a part of my fence and the HOA fence so they can access another part of the HOA property. He has told me in the past he wants to have access right next to my driveway into that. My wife, we don't want him anywhere near our house. And I feel that I have that right. He can walk around to access that property. There's another access point. I do not want Mr. Kirby near my house.
Okay. What I'll tell you is, one, I'm not going to get into the activities of the HOA. That's not part of this statutory proceeding. Number two, Mr. Kirby's heard what you've said. Mr. Kirby's has a protection order on your behaviors towards him. Mr. Kirby, you've heard what Mr. Burt has said. I hope you're respectful of that within the context of your obligations to the HOA. Maybe somebody else from the HOA can do it so it doesn't aggravate Mr. Burt. But if there are issues, Mr. Burt, you're going to have to deal with it through the HOA. You may have to hire an attorney, those sorts of things. But that's how it's handled.
Thank you. I just wanted to make note of that. Thank you, Your Honor.
All right. Thank you both.
Thank you.
Evan Branscombe, Christopher Linkus.
Hello.
Good morning, Your Honor.
If you both raise your right hands for me, please. And Ms. Branscombe, two of you used to be in a dating relationship, is that right?
We were not fully dating, but yes, pretty much.
Okay, so you were dating some. It's the degree that we're talking about, is that right?
We were in a former intimate relationship and I ended things, and that is when it started to escalate.
Okay, all right. And you indicate that Mr. Linkus has stalked your residence, he's gone to your work, he's talked to your coworkers, all with the intent of maintaining some contact with you. Is that your position?
Yes.
Okay. Anything else you want to add to that?
No. I can go into more detail of things that have happened, but no.
And then you believe somebody punctured the tire of your automobile and you believe it was Mr. Linkus. Is that accurate?
I don't have proof it was him. It happened the night that I ended things after I dropped some stuff off at his house, which was very convenient timing. I don't know of anyone else that would have any reason to do that. I have a paper from the Les Schwab I went to that said that my car was vandalized and that the sidewall was stabbed.
Okay. All right.
The night
you indicate
after, sorry.
You indicate in your petition that you have video footage of Mr. Linkus coming to your house at night. Tell me about that.
Yes, so the night that my tire was stabbed was the night that I ended things. The day after that, I was outside with my dog and he drove past me. He drove right down the road past me and my dog went around my cul-de-sac and then pulled back out of the complex. I went to my office and tried to pull up camera footage. There is camera footage of the vehicle leaving my residence.
As in leaving the driveway of your residence?
I live in an apartment complex. He left the complex entrance that night. He came in, went around the cul-de-sac, and then left out the entrance.
All right. And Mr. Linkus doesn't reside there?
No.
And this was the night after the two of you broke up?
Yes.
Okay. All right, Mr. Linkus.
Your Honor. So my response, I did file a declaration with the supporting exhibits in the response to the petition. I do respectfully oppose entry of the final anti-harassment protection order, and I asked the court to deny the petition. I appreciate this time and I understand the seriousness of these proceedings. I've compiled, I complied with the temporary protection order since I was served, and I've had no contact with the petitioner. I do respectfully dispute several of the central allegations that are in the petition. Specifically, I did not go to the petitioner's residence after our relation ended. I did not damage her tire or any other property. I did not engage in continuing course of conduct intended to intimidate, threaten, or frighten her. The petitioner and I briefly had a friendship for 16 days during July. During that friendship, I was invited to her residence on multiple occasions and stayed overnight by mutual agreement. After the relationship ended, however, I did not return to her residence. The allegations that I went to her residence after the relationship ended is false. I did not return to her residence uninvited, appear there at night, or monitor her residence. I have not seen any evidence establishing that I was at her residence after the relationship ended. I also categorically denied the damaging the petitioner's tire. I did not place anything under her tire, puncture it, damage her vehicle in any way. I have no knowledge of her tire becoming damaged. I do respectfully ask the court to consider whether there is evidence connecting me to that alleged damage rather than simply the fact that the damage occurred. The incident on July 26th, Your Honor, I do have the events there. The petitioner and her coworker came to my apartment complex without prior notice after quiet hours and began yelling throughout the parking lot as I was returning to my apartment. I did not approach them, argue with them, or engage in any confrontation. I just returned to my apartment and went upstairs. I included this because it provides context concerning the interactions between us immediately before the events described in the petition. I have also submitted the actual communication between us, the messages that include statements made by the petitioner herself. And I would ask the court to consider the messages in their entirety, rather than my characterizations of them. The petition also states that I told the petitioner I loved her and combined our last names. I denied both allegations. I never told the petitioner that I loved her, and I never combined or suggested combining our last names. We did have the incident at Safeway. I do want to address that as well. I acknowledge being at the Safeway where the petitioner worked. However, I've been a regular customer at that Safeway for approximately 10 years before ever meeting the petitioner. I routinely purchase groceries and my son's prescriptions there, as well as mine. On July 7th, while I was leaving the store, the petitioner and another employee approached me from behind, and I was accused of damaging her tire. I denied the allegation. The following day, I did speak to the store director about what had occurred in that conversation. I understood that I was permitted to continue shopping there. On July 30th, though, the store director did inform me that I needed to leave, so I immediately complied and left without incident. I was not repeatedly returning to Safeway for the purpose of contacting or monitoring the petitioner. And then just to close things out, a prior DV matter that was mentioned, I do want to address that. That was referenced in the petition. I'm not attempting to hide any of that history. That matter involved my former spouse several years ago and was resolved through the legal process. Since then, me and my former spouse successfully continue to co-parent our son who has special needs and do share our 50-50 responsibilities. I just respectfully ask the court to determine whether the allegations involving this petitioner has been established based upon the evidence concerning this case, rather than treating the prior matter as proof of these allegations occurred. And then just to close it, Your Honor, I understand why these allegations of this nature must be taken very seriously, and I have respected the temporary protection order that was served. But I do respectfully submit that the central allegations against me have not been established by preponderance of the evidence. I did not go to the petitioner's residence after the relationship ended. I did not damage her tire property. I did not engage in a continuing course of contact intended to harass, threaten, intimidate, or frighten her. When there are interactions at Safeway, I have provided context surrounding those interactions, including my longstanding use of that store and my compliance when management ultimately asked me to leave. I have provided my declaration, timeline, communications, and supporting evidence so that the court can evaluate the allegations based on the actual record. And for those reasons, I respectfully request that the court find that the requirements for the final anti-harassment protection order have not been established and deny the petition. Thank you, Your Honor.
All right, thank you. And Ms. Branscombe, anything else you want to add?
There has been harm at my store. How this
So-
all started was
Yeah, Ms. Branscombe, your audio is breaking up. I don't know whether you're too far from your device or in a bad location?
Okay, I am not sure what's going on.
Okay, so let's just leave your video off. Right now we have good audio. Do you have anything else you want to say in response to what Mr. Link has previously said?
So, in regards to him saying that he was not causing harm, the day that I ended things, he approached my coworker. She works at Starbucks and she was trying to make customers drinks. He approached her and told her that we had broken up. In regards to just a friendship, it was definitely more than that. He was constantly wanting to have sexual interactions, and we did on multiple occasions. He would get quite upset with me when things didn't go the way he wanted. He would tell me that I was a turnoff when I ruined the mood for him. We had taken a shower together and we did not have sex, and he was upset after that shower because we did not do anything. So on top of coming in and talking to my coworkers about how we broke up, I was answering a phone call at work and I was on the phone with a customer in the middle of speaking. He walked past me and yelled at me to bring his shit back to his house. The stuff that he wanted me to bring back was a TV that he left on my doorstep. I told him I did not want it because my TV had broken, and he left it on my doorstep with a note. I do have a video of that. He left it against my will. And so I took the TV back to his apartment complex. I did go with my coworker because I did not feel comfortable going there alone. When I showed up with my coworker, he was outside his vehicle. I asked him why he was out there because I did not want to have an interaction with him. My coworker left the TV at the bottom of his stairs. She did not interact with him. And then as he was heading in with the TV, as he says I was shouting, I was not trying to shout. I simply told him to stop talking to my coworkers about me, because he also approached another one of my coworkers and told them that he was upset at me. And they had no idea what was even going on between us. It was really just uncalled for. My coworker also states that he called her an effing bee and that he flipped her off when he was walking past. And yes, I would just like to state that it was definitely more than a friendship, and there were a lot of encounters between us, and I ended things because of the behavior that I was seeing previously, such as him getting mad because I was spending a night at my friend's house. That's how this all started. Thank you, Your Honor.
All right. So after the incident with the return of the TV, has there been any contact from Mr. Linkus?
He was shopping in the store. Well, not shopping. He loiters at the Pokemon machine on a regular basis. He rarely buys things, maybe a donut, maybe a couple items, but he usually just comes in and stands at the Pokemon machine by Starbucks. He will spend hours in the store. The day I ended things was the day that he was approaching all of my coworkers. The next day he came in, he spent almost the entire day in and out at the Pokemon machine, standing at Starbucks. And that is the day that he got into it with one of my coworkers. I asked him if he popped my tire. I did do that. He said no, and I walked away. And that was the only contact we had. After that, him and my manager had gotten into an argument. I'm not sure what happened there. But then he came in with his friends and asked to speak to our manager, which I am one of the management people there. And my other manager handled the situation and talked to them, and they requested that we call HR and requested that we file a report because he was being harassed.
Okay. So back to my question, after the TV was dropped off, has anything happened since then?
No, just the fight that happened between my coworker and him. And they were all standing on a check stand behind me while I was trying to help a customer. And they were all kind of arguing. After that, he was trespassed by my store director, who verbally asked him to leave because of everything that was going on.
Okay, thank you. And Ms. Branscombe, do you have any information that Mr. Linkus owns firearms?
He told me he does. I do not really have any part in it. I did not see any. All I know is that he stated that he does in private with me.
Okay, but he's never threatened you with one or
No, I'm
brandished
not concerned
you
about
or
that.
anything?
No.
Okay, all right, thank you. All right, and Mr. Linkus, I did review the exhibits that you filed, including your timeline summary and your statement. So I had previously seen that, and I wanted you to know I did read it and consider it. I am going to grant Ms. Branscombe's order. This is the way we determine these hearings is using what's called a preponderance of the evidence standard, which means I just have to be slightly convinced that there's a need as opposed to not being a need. So in this case, I will find that there's a basis for me to enter this order. So Mr. Linkus, you're to have no contact with Ms. Branscombe. You're not to harm her in any way. You're not to engage in any stalking behavior concerning Ms. Branscombe, and you're not to go within 1,000 feet of Ms. Branscombe, her residence, her vehicle, or her workplace. Those are the same conditions that had previously been imposed in this case, and they remain because they are the same conditions, and because you appeared today, there does not need to be further service of this order. Ms. Branscombe, this order is in effect for 1 year from today's date. If you want it renewed, you'll have to come back to court and petition for renewal. All right, thank you both.
Thank you, Your Honor.
Your Honor, can I ask a question?
You may.
With my son, I am a volunteer at the school. I attend field trips. I help in the classroom because, again, he does have autism. I do have concerns that this could impact my opportunity to continue to volunteer at the school. And I just wanted to ask about that while we're here, and also regarding the firearms. I was served, what was it, Friday night before the hearing, when I was giving my son a bath. I did not receive a receipt of surrender, so I still have to work that out with the officer with the paperwork, but I just wanted to ask for more clarification on those two things.
Thank you. As to what happens in your volunteer work, typically folks are looking at criminal convictions. This is not a criminal conviction. This is a civil order. Now, they may look at that. I'm not going to change what I do because they may look at the civil order. The civil order is for a separate purpose, and I have entered it based on that purpose. But for your information's sake, it's not a criminal conviction. So if they differentiate between those two, then you should be okay in that regard. Hearing the testimony of both of you in this case, I didn't find any basis for a firearms restriction. So I'll note that in here, and you can get a copy of this order and take it to the police and have any right to possess firearm restored.
Yes, Your Honor.
Okay. All right. Thank you.
Who do we have in the jail? If you could identify yourself in the jail.
What are you talking about?
Yeah, what's your name?
Lovett.
Okay. Good morning, Mr. Lovett. This This is Timothy Lovett, cause number T00586-257. Mr. Lovett's presence in custody. Mr. Haverco, is this matter on for, is this on for arraignment?
It is, Your Honor, and I believe, well, I'm thinking about a different case. So yeah, no, this matter's on for arraignment, and
this is real.
and this is in light of the we recently had, as you know, Your Honor, we recently had a report with respect to his competency kinds of issues.
Right. And Mr. Ratfield, that was, I think we received that probably 3 weeks ago. Is that about right? A month ago, maybe?
Yeah, less than a month ago. I'd say probably 3 weeks ago.
So my experience with that is we, and again, Mr. Haverco, I'm assuming you haven't met with Mr. Lovett. Is that correct?
No, not as of yet. No.
Okay. So Mr. Lovett, do you know what you're here for today?
I was brought in on a charge that's not consistent with the nature of the issue that brought me in here.
Okay. Yeah, I think
I broke out a window at my house, and I've been charged with domestic violence. This is 4 months ago. I came in, I came out one time.
And Mr. Lovett, I'm gonna just, I mean, Mr. Haverco would probably be advising you not to speak about the case right now. There may be some legitimate issues.
Right.
Mr. Haverco, I'm inclined at this point to appoint you to Mr. Lovett's case. And then when you can get in and see him, then we can maybe have a discussion about how things are at that point.
Okay.
So, Mr. Lovett, I'm going to appoint Mr. Haverco for purposes of today's hearing and moving forward. I know there's been some history with you.
Am I being released today?
What's that?
Did I get released today?
Well, we're going to have that discussion here shortly, okay?
Okay.
Okay. So, Mr. Haverco, I'll go turn it over to you.
Well, pursuant to your ruling, Your Honor, would stipulate to probable cause and ask the court to enter not guilty, please.
Okay. So, Mr. Lovett, what we're going to do is we're going to enter a plea of not guilty to the charge in this case, which is 1 count of protection order violation and 1 count of controlled substance knowing possession. This no contact order, Mr. Ratfield.
Look, I need, this woman has control of my money. I went to go get my, I'm literally being bled dry. Look, I need her to go to my house. I need to get my clothes. I need to get an account number. I need to go to the bank. I need to switch my money that's coming from the government into my account. Because she's taking my money. I'm not getting anything for it.
So, Mr.
I went to go see this happen. They called the cops, bring me in on this. I'm sitting here gonna literally die because I'm not getting what I'm supposed to get. She's spending else. This is supposed to be my payee.
Okay.
This isn't what they're doing to me is terrible.
So, Mr. Lovett, I'm going to stop you for 2 seconds. Does this individual, does she reside? Mary is her name. Does she reside at the 15823 105th Way Southeast address?
That's where I've been living. Look, this whole thing is ridiculous.
I know. Well, let me just, does she reside at that residence?
Yes.
Okay. And so that's where you reside as well.
That's where I had been residing.
Okay.
They removed me over a year and a half ago on a charge that's not consistent with the nature of the crime, meaning it's a bullshit crime.
Yeah. So
the cops are literally trying to fuck me out of my house.
Yeah, Mr. Lovett, let me stop you again for a second. So, Mr. Ratfield, I'm gonna turn to the city and have a discussion with the city prosecutor regarding conditions of release.
I need a escort to go to that house to get where I
So,
need.
Mr. Lovett, that's the question: is if you are released here, you're not going to be able to go back there without a civil standby.
How do I get a civil standby?
You go to the police and they will let you go get your clothes. They'll let you
Uh-huh.
go get whatever stuff that's there. But they're not going to let you engage with this Mary individual.
Okay.
They're not going to let you, get account numbers. But if you're
I gotta
released,
get my account number.
you'd have to go to the bank wherever the account is.
Look.
All right, that's something you can maybe deal with. But let me hear from Mr. Ratfield regarding conditions of release.
The city's not comfortable allowing Mr. Lovett to be released on his own recognizance without a discussion with the alleged victim, Mary Lovett. First, city's going to be asking for bail in the amount of 1,000 cash or bond.
There's not money. I don't have money. She has all my money.
Okay, hold on, Mr. Lovett. I'm going to hear from Mr.
Account, and then I have my account.
Hold on.
Cut me off from the shared account. It's all the money I have.
Yeah. Hold on one second, Mr. Lovett. Now I'm going to hear from Mr. Haverco. Mr. Haverco.
Well, I can understand the city's, concerns, probably being propensity to commit violations, looking at his, I don't know if there's some kind of assurance, maybe Mr. Lovett, you can, provide the court, I think, as court's heard, he just wants to, kind of get this money property issue resolved, and
I have no way to bail out. So guess what? I'm broke, homeless. I can't even get to my money. Look, all my SSI money gets put under her account, and then she moves it over to the account that's in my name. I need it put into my name. I've been over there 3 times. I've been back to this jail 3 times. Every time. And now you want me to bail out when I got nothing? She's got everything and she's giving it to somebody who's having sex with her. I'm getting fucking destroyed in life over some asshole. Destroyed in life over some fucking asshole.
Mr. Lovett, I wanted you to calm down for a second. I want to hear from Mr. Haverco some more. So go ahead, Mr. Haverco.
It looks like if we go past and if we go prior to May, which is the last string of charges in Yelm, prior to that, we really
told you I'm being predatorily stalked, motherfucker. I've been attacked twice. My nose. Look, I've been attacked.
Mr. Lovett, again, I really want to hear from Mr. Haverco. If you can just sit tight for a second, let me hear what Mr. Haverco
I've
has to
been
say.
predatorily stalked. I've been homeless for a month and a half over fucking Social Security being stolen. I can't even go into that place, get her to switch the accounts. Money that's been coming in from the government over to my name with some fucking piece of shit having sex with her for money. Talking shit about me. This is fucking insane.
Mr. Haverco,
I'm
go
literally
ahead.
sleeping on the fucking streets, motherfucker. You want $1,000 to get out of here? He has my money because he's having sex with my mom. He's younger. She's a fucking weirdo, motherfucker. That house is in my name.
All right.
I just note that the last time we have, actual convictions, you do have to go back a ways. At the misdemeanor level, actually quite some time ago, it looks like the first, actual conviction I'm seeing is 2015. And at the Superior Court level, there was something that was dismissed. Let me see what the code is. It says dismissed with existing sentence information. Not sure what that means. That's from the 2022 case in Superior Court. And then there's a conviction, from 2019 and a few prior to that. But I guess the point is that he doesn't actually have much in the way of current actual, convictions. And so, if we could just give assurances to the court that he won't have contact with this person, except without.
I need a way to get to my fucking money.
Right.
This bitch is fucking bleeding me dry.
Mr. Levat,
I'm
can you
being predatorily stalked.
Mr.
That fucking
Levat,
house is in my goddamn name.
Mr. Levat, if you could
Not
just
even Mary Lovett, motherfucker. This is crazy.
Yeah.
Mr. Levat, if you could just calm down a little bit, is there any way you could just give an assurance to the court that if released, you won't have any contact with her
I need a way to get
unless it's accompanied by a police escort?
Yeah, Mr.
I'm
Mr.
fucking
Haverco,
homeless on
I'm
some
gonna
bullshit.
stop you at this point. So, Mr. Levitt, I really wanted to hear from Mr. Haverco. You've interrupted multiple times. You're clearly angry about this. I get that. I don't know if there's services in the jail that can help you change your account, but you're not giving me, I'm not getting much assurances that letting you out you're not,
Look,
once you get out, you're not.
I need a way. What do I do? How do I get it so I can go get my stuff at the house?
So,
How do
Mr.
I get it
Haverco,
so
is there a
she-
way,
Look,
are there?
Don't you think it's a little ridiculous that she became my payee? I got a huge increase in fucking Social Security, and then she turns around and I'm homeless, and she's not giving me the money. I went fucking starving on the streets, been attacked twice, and she won't even transfer the money to my account.
Okay. What I'm gonna do, Mr. Levitt, is this. I'm gonna ask
Look,
Mr.
I need
Haverco.
a way to deal with this.
That's what I'm gonna
come
have.
to this fucking jail.
Mr. Levitt, I'm going to have Mr. Haverco come and, Mr. Haverco, I'd like you to go see Mr. Levitt when you can. And I'd like you to talk to him about who he needs to get a hold of, how we can get him assistance with this payee issue.
Okay.
So Mr. Levitt, Mr. Haverco, I'm going to hold you on $1,000 cash or bond, but Mr. Haverco is going to help you with this. Okay? I know, listen though, if you post, great. If you don't post, Mr. Haverco is going to come over and help you try to figure out how to get this out, get this dealt with. The other thing is there may be some people he can talk to or give you some phone numbers, or maybe he can make some phone calls to some folks at the SSI folks.
Bill is too much.
I know, but
I got nothing.
But Mr. Levitt, the other thing is this: we also have court this Thursday. So worst case scenario, we're going to see again on Thursday, and then that time I can talk to Mr. Haverco about what we've got going on.
You guys aren't even real, man. None of this is real.
So
that fucking destroyed my goddamn life over fucking.
Yeah, Madam Clerk. So
$1,000
cash or bond. If he posts no contact with the address at question, we'll give him a standby. Civil standby is approved if he posts. Otherwise, I'd like him put back on the calendar for Thursday morning. That we can address this issue again.
So
and in that time, I'm hoping Mr. Haverco will have had a chance to maybe talk to him and maybe get some numbers and assist him with this issue, this payee issue, because that's something that I think Mr. Levitt, you might be in a better position if you don't post and have Mr. Haverco help you with this. He's willing to help you, but you've got to listen to him. Okay?
Yeah, I'll do what I can, Your Honor.
Your Honor, do you want just the no contact with just the address or also the?
Well, I want the address, but he has to abide. There's already an existing no contact order that he has to abide by.
Okay.
Okay. So, but in the interim, Mr. Levitt, I'm going to task Mr. Haverco with helping you out with this over the next couple of days, and hopefully we can get this worked out, and so that we can get it taken care of, and we can get you in touch with the right people to get your payee changed. So I want you to start thinking about who the payee is you would want to be on this.
Can I say, I've asked a few officers before, but I was needing a restraining order on Officer Garcia. For harassing me and my girlfriend.
And Mr. Levitt, I don't know anything about that. I'm going to defer that one to Mr. Haverco when he comes sees you as well. He can talk to you about that. But you got to have a conversation with Mr. Haverco. He's there to help you. I'm appointing him to help you at this point. He's going to be over to see you there shortly. Okay. Okay. And that's all for today. So, Mr. Levitt, if you can go to the door and let the folks know you're done for today. And worst case scenario, we'll see you Thursday morning. And in the interim, hopefully Mr. Haverco can assist you with this payee issue. Okay. Madam Clerk, I'm going to sign the. So, Madam Clerk, how are we doing Thursday morning for numbers wise?
Um,
For in custodies.
this would be the one and only, Your Honor, at this time.
Okay, perfect. August 13th, 8:30, Mr. Levitt, that'll be your next court hearing. Hopefully we'll have some information on the status of any pay issues. And again, Mr. Haverco is a smart guy, and hopefully he can assist you with that, and we'll go from there. All right, that's all for today for this matter.
Is that something I can get assistance with? 'Cause all the officers just ignored me, and I got attacked worse by the officer Garcia.
Yeah, they're gonna come in, they'll just, the clerk's gonna, if you want to stand up and just knock on that door behind you, they'll come and let you out. And then Mr. Haverco is gonna be over there and see you as soon as he can. Mr. Haverco, yeah, if you just stand up.
I'm Gerald Christopher.
What's that?
I'm Gerald Christopher.
Oh, we got switched. Okay, sorry. Sorry, you got switched when I was looking at something else. So Mr. Lovett's already been removed, Mr. Haverco?
Yes, Your Honor.
Okay, sorry about that. All right. Okay.
But I had the issue where I kept being harassed by an officer Garcia.
Okay, we're not going to deal with that issue today.
Well, I've asked a bunch of officers about getting a restraining order, and it still hasn't stopped. It just got worse.
Okay. All right.
It keeps harassing my girlfriend.
Mr. Christopher, let me call the matter. This is City of Yelm versus Gerald Christopher, cause number T00508503 and T00487051. Mr. Christopher is present in custody. Looks like these are warrants. These are both on pretrial status, Mr. Haverco. Have you had a chance to meet with Mr. Christopher?
I haven't, but Your Honor, I was previously appointed a month ago or so, and then we had a pretrial scheduled.
Yeah,
that was recent, and then he dismissed his pretrial, and then the court issued a
warrant. Okay.
I didn't have a piece of paper with a date on it, or I would have been there.
Okay. All right. So, Mr. Christopher, you got your wires crossed and missed court.
Yeah, I didn't have it written down. So if you could reschedule it, write it down for me, I'll make sure to be there.
Yeah. No, I get it. Let's hear what's the city's thoughts on this.
The city's fine with Mr. Christopher quashing the warrant today.
Okay.
And
All right,
being
Mr.
released.
Christopher, we're going to release you on your own recognizance today. You now know what's going to happen if you miss court. Okay.
Okay.
So we're going to give you a piece of paper. All prior conditions remain in effect. I see there's been no new law violations since June, so that's good. How are things going? Decent?
Yeah, but things are going pretty decent besides being harassed by that officer.
Well, again, different issue. So at this point, we're going to release you on your own recognizance. I'm going to give you a court date. It's not going to be this Thursday.
Could you have it closer than farther out? I'd rather take care of it sooner because I like the chances of me missing court or missing.
Yep, I get it. So the earliest we can do it would be August 27th, if there's any dates available on that date, Madam Clerk.
And what day is that?
It's a Thursday. It's 2 weeks from this Thursday.
All right, yeah, I can do that. That's way sooner. That's way better.
Madam Clerk, can we fit him in on the 27th?
Yes, at 10 a.m.
Okay. Next court date, Mr. Christopher, is going to be August 27th at 10 a.m. And again, you're going to get paperwork that says this.
Okay.
So just yes, sir, or no, sir, to the police. They're going to give you a copy of this, and we will see. Mr. Haverco's contact information is on this document as well. I want you to reach out to him. Okay. All prior conditions remain in effect, and we'll see you back here on August 27th at 10 a.m. Do not miss court. Okay?
I won't.
Okay, that's all for today.
So I'm out of here today?
You should be out of there today unless there's somebody else holding you.
All right. Thank you, officer. Thank you, Judge.
Yep. Good luck to you. We'll see you on the 27th.
Yep. See you on the 27th. Have a good day.
You too.
Yep. See you on the 27th. We might. I can never predict this. Well, ladies and gentlemen, it's been another evening. It's been another full evening. Start things off, Judge Stevens. Move quickly on into some Washington State action. It just stayed in Washington State pretty much all night long. I look for any sign of Miss Donahue today, and no, she wasn't there. Maybe next week. Maybe next week. But I feel sure, for those of you who know, Miss Donnie will return. And we have quite a few tonight who probably will be returning also. I said a nifty little, hey, let me set a nifty little reminder for a few of those cases earlier on in the day when I was watching some of this stuff. So we'll be having something to look forward to. I love music too, guys. I do want to say a big thank you to Specs and Darth Steven for your most generous contributions to the stream this evening. It is because of donations like those that we get to do things like this. And I also want to thank all of the people's names scrolling across the screen right now. And look who's at the top. Specs and Darth Steven. Go figure about that. Well, PBO's kind of interesting today, I thought. You had a lady who called in because she was all freaked out. She wasn't allowed to call in at first, and then she said, this is important. Call in. I thought that was good. Right decisions made. Right fight to fight. Make your court appearance. Even with something like that, especially with something like that. That last guy though in Yelm, could not keep his mouth shut for anything. I thought there was a big lesson to be had looking at those two back to back. The guy who was just barking mad, and then the guy who was mad about, he wanted some type of protection against this police officer who was just hounding him. But because he stayed calm, a little bit collective, and for Yelm, Washington, not crazy at all, he's out tonight. He's having a burger someplace. He's having some fries. He may actually be watching this stream and we don't even know it. Crazy things that don't happen. But even if he's not, I want to thank you, everybody who has been here with us tonight. It has been an amazing chat. I have had a wonderful time, and we're going to do it again, just like we do every single day. Same Wolf time, same Wolf channel. That's 8 p.m. Central Time, 9 p.m. Eastern. Tomorrow, the day after that, the day after that, and the day after that. But for now, I'm your Lone Wolf Usul. I'm your humble curator, your host for these here get-togethers. And for now, I'm out. And remember, only you can take a bite out of crime. Bye!